volume 4A. Now, you just read it. The right of conferring or granting degrees shall be exercised only by a university, established or incorporated by or under a central law, a provincial law, or a state act, or an institution deemed to be a university under section 3, or an institution specially empowered by an act of parliament to confer or grant degrees. So whether as a matter of law, I can't get a degree, I can't be called a university unless I'm incorporated under the Central Act. Now, where does this provision come from?
Mr. Sibbal,
Yes.
please refer to section 23.
Yes,
In this case, the proviso will apply.
Yes.
And 22 may not apply.
No institution, whether a corporate body or not, other than a university established or incorporated by or under the Central Act or a province or a state act shall be entitled to have the word university associated with it, provided that nothing in this section shall for a period of 2 years from the commencement of this act apply to an institution which immediately before such commencement had the word university associated with its name.
So what happens is, in this case, because it was already a university,
Correct.
by a Central Act, is the proviso which will come into play, and for a period of 2 years there was hiatus. They could then apply and confirm, or the UGC will confirm their status as a university.
Correct.
And accordingly to proceed. In this case, because it's more than that, because they were already included in the 7th schedule entry 63.
Yeah. But I'm not in that context.
22 and 23 occupy different fields.
Yes.
22 deals with the right to confer a degree.
Yes.
23 deals with the use of the expression university as part of your name.
Absolutely. I pointed out 23, my Lord pointed out 22. But Manas, I have a different argument to make. What my Lord is saying is absolutely right. But my argument is, where does 22, 23 come from?
Let's read 22(1) again.
Well. The right of conferring or granting degrees shall be exercised only by a university established by or incorporated by or under a central act, a provincial act, a state act, or an institution deemed to be a university under section 3 of an institution specially empowered by an act of parliament to confer or grant degrees. The question that your lordship should ask yourself is, where does this come from? Where is this provision? What's the origin of this provision? And the answer is 1906. Now let's go to 1906. Let's go to 1906. That's to answer my Lord's question. Because Aligarh Jung was then the Vice Chancellor. There was an agitation because the institution, remember there's a school there, there's also institutional reservation that was reduced from 75 to 50%. There was a huge agitation all over the country. And the Aligarh Jung was injured in the process and he was manhandled. So therefore, as a temporary measure, they sort of said, we must stop this maladministration. That was the reason for this. But kindly see, Malas, at this at volume 4C, page 1325. What Chagla says, Malas, in Parliament. Speaker on the right-hand side. As we all know, we are facing a very serious crisis just now. There is aggression, there is undeclared war. We should do everything in our power to maintain communal peace and harmony. We should not say a word which will interfere with the harmony which exists and which should continue to exist. Today we should think of ourselves not as Hindus or Muslims but as Indians, one and all. I wish this reverberates, it reverberates in India as we stand here. Now I am a great deal in agreement with what Mr. Mukherjee said. I have said this before and I repeat it. I repeat, it with all the emphasis I possess that this bill will not in any way affect what Sri Mukherjee chooses to call the special character of the university. The academic council has not been interfered with. This bill does not touch the academic studies in the university. The academic studies will go on as they are. I also reiterate what I said before, that this is a temporary measure. Kindly note that. An emergency measure, and a permanent bill will be introduced as soon as possible, if possible in the next session. Then next he says, it should be a symbol, it should be a symbol of Muslim culture in the context of secular India. It should be an example to the rest of the world how different communities can preserve the glory of Aligarh. I know it has made a great contribution to our academic life, our scholarship and our nationalism. I want to assure this House that I have brought in this ordinance and the bill as a temporary measure in order that Aligarh should be strengthened and should become a modern progressive university, that it should be a shining light not only in India but abroad of our great composite culture.
What was Mr. Shyam Prasad Mukherjee's objection to this? When he said Mr. Mukherjee, that was Mr. 65, sir.
H.N. Mukherjee. We are on administration. So really that takes care, Malas, of what's right and what was wrong. So Malas, I've done that, and the last thing now, then I've done it. What is the last thing? What is it that we brought in and what was transferred to Aligarh Muslim University? 1. 30 lakhs raised by the Muslim University Association, which is worth 300 crores today. In 2005, it was valued at 287 crores. This is reflected in Section 7 of the 20 Act. Section 7 of the 20 Act, Volume 3G, at page 7. Section 7 of the 20 Act, Volume 3G, at page 7. And the Muslim University Association stood transfer to AMU. So all land, all infrastructure, movable, immovable properties of the AMU College and the Muslim University Association took transfer to AMU. So all the assets, movable, immovable, all transferred. That's at Section 4.1 of the 20 Act in Volume 3G at page 6. Section 4.1 of the 20 Act, Volume 3G, page 6. The next is even more important. Any property given to the MEO College or Muslim Association by gift, trust, would be read as will gift to MOU. Kindly see, this is a private, your Lordship knows. A will is a private act, and a private instrument. Even that, is deemed under the act to be given to be a gift. Even government land becomes theirs, This shows continuity, This is Section 4, small Roman 4 of the 1920 Act. Section 4, small Roman 4 of the 1920 Act, Volume 3G, page 6. Then, all buildings of MEO College. Next, all buildings of MEO College were to vest in the AMU. And the same name were to be kept of those buildings. Names could not be changed. That's, Section 4, Roman small 5 of the 20 Act.
Section 4.
So this is how, the continuity is established, the genesis is established, the foundation is established, and Basha acknowledges all this, but it says doesn't matter because there's an act. It matters. Matters because this is the only institution of its kind set up with intent to serve the interests of secular India and to protect the minority institutions in empowering their children and others to be part of the workforce of India. If you reject this, you destroy that dream. That dream should not be destroyed. Thank you very much.
Thank you, Sir. Yes, Mr. Khurshid?
The Lordship may pardon me for a while.
Yes.
Well, please, Your Lordship. Lords, I adopt whatever my learned colleagues have said, Lords, with appreciation and gratitude. I'm only picking out some first principles, Lords, that would, I believe, assist Your Lordships in coming to a conclusion, which essentially, as I understand, is simply in the backdrop of whatever has been explained to Your Lordships, whether the establishment word used in Article 30 leads to a situation in which everything is there except the actual act of establishing it by an act of Parliament. Does that take away? So, my lords, essentially, there are three propositions that I'm placing before your lordships. Lords, very, very briefly, in a few minutes, the backdrop of Aligarh Muslim University. Because your lordships have been told how Sir Syed Ahmad pursued the establishment first of an AMU college, and then his followers pursued the establishment of the university. Because the matter begins with 1957, and the Sir Syed wrote out this great book, the treatise about the reasons for the uprising, the mutiny, or what we call independence, the war of independence, the first war of independence. And thereafter, one of the important causes for him, as he found, was the backwardness of Muslim community, particularly the educational backwardness of the Muslim community. So he set out to bring about education. He had already set up something called the Scientific Society, the purpose of which was to translate scientific books into Urdu so that they could be made accessible to the community and make the community more aware of what the scientific developments were happening. And that was Sir Syed. He then, my lords, after 1857, he visited Oxford University. He tried to absorb and understand how a good university could be made. And then, of course, the same designs of Oxford University were reproduced in the architectural plans of what was AMU College and then Aligarh University. Of course, we didn't have in colleges as Oxford and Cambridge have, but the buildings were designed around what are called halls of residence. It was to be a residential university, so there were halls of residence, each hall having very eminent background and each hall having a particular character. So, my lords, there is what is called in Aligarh an Aligarh Tehzeeb. It's very important. And I'm saying all this, my lords, because I have a sentimental attachment to Aligarh. I was born in the Vice Chancellor's house, and therefore I do have a claim sentimentally on Aligarh. But be that as it may, my lords. There's a particular tehzeeb translates into culture or a subculture that Aligarh represents. I do believe there's a culture in every great institution. Lordships know culture in every great institution, but Aligarh has a unique culture, which a great deal has to do with ability to speak, ability to propound, ability to interact, ability to imagine, and to project. My lords, this is seen right through the Aligarh University's culture. My lords, so when the university is established, your lordships have also already seen that it was established with the effort of the community. And therefore, I distinguish in first principle two kinds of establishments, well, two kinds of statutory acts that may be propounded by government. One is a non-consensual act, where, well, it's an institution that is fallen on bad times, where there is widespread talk of corruption, that people are not being served as they should be served. And the government steps in to say that in order to save this institution, we need to take it over. And they take over that institution. It's a non-consensual strategy. But there can also be a consensual takeover, which is exactly what Aligarh was about. where everybody gathered and said, please convert us into a university. And as Mr. Kapil Sibal just argued, all those assets and the entitlements of AMU College were handed over to the university. Malad, two things have happened. When Aligarh Muslim University Act was passed in 1920, it was not assumed that there would be a difference between two different kinds of universities, which we now have become familiar with, private university and a public university. Your Lordships asked what minority institutions or university level institutions are there, and it seems that Aligarh being one, provided your Lordships agree with us, Jamia University is the second one, dependent on whatever the decisions will happen in Aligarh. Jamia was a breakaway offshoot of Aligarh. Jamia was part of the independence movement because in the independence movement, it was felt that whatever...
We are not dealing with Jamia's case because that's a separate matter. So if you want to go into that, maybe expanding the scope of the reference.
Well, I'm only saying that your Lordships asked me if there were more than Aligarh institutions that were... The moral principle is best understood. They must decide whether the true ground of the moral principle that condemns censorship in the form in which this principle has been incorporated into American law extends to the case of pornography. Then the next paragraph, the moral reading therefore brings political morality into the heart of the constitutional law. But political morality is inherently uncertain, etc., etc. Well, then this article goes on to what are the alternatives to this moral view. I would argue, my lords, that this moral view that Dworkin has suggested is already reflected each time your lordships have said that there is a constitutional morality that we must submit to, initially known by way of constitutional values, but your lordships have now talked about constitutional morality. The political morality that Dworkin talks about is similar to constitutional morality that your lordships have applied. And constitutional morality looks at the constitution as a whole, not in pieces, etc., to arrive at an integrated idea. And I submit, my lords, that an integrated idea of constitutional morality would certainly point your lordships towards coming to a conclusion that minority rights can't suddenly disappear by way of an artificially restricted interpretation of a word like established. Because that's basically my argument to essentially support what all the other council have argued, that this is an additional reason, the moral reading of the Constitution that will give your lordships this conclusion. I am deeply grateful, my lordship.
Yes, Mr. Farah, sir.
As I am appearing in Civil Appeal 2316 of 2006, that's 701.7 before your Lordships Board. Your Lordships in this 7-judge combination are being essentially called upon to interpret the word established in Article 30 of the Constitution and whether the meaning of established as given by Aziz Basha is correct. Because if I have understood the core purpose of the reference. Because I begin my submissions by borrowing from my Lord the Chief Justice's observation today. Because how do we read Article 30? Do we read as something which creates a ghetto? Or is it for a larger purpose? Because my respectful submission, and I just flagged those two submissions there, but just as opening I'll flag those, is that in any country, a minority craves for two things, which Article 30 recognizes. And those two things are firstly, to retain its minority identity. And secondly, while retaining its minority identity, to fully and completely participate in the national life and national mainstream. Plus, in my respectful submission, Aziz Basha, apart from the specific reasoning, proceeds on the basis that you can do either one or the other. You can't do simultaneously both. So you can be a minority, you stay in your space, But if you become a university and the law requires you to, the parliament to enact something, then you lose your status. You can't be both. If you have provisions in your statute which permit others to be part apart from the community for which it is being established, that may disentitle you. Because that's the background. Because the second background submission is that you lordships will bear in mind that AMU, because today we are testing AMU status in 2024. In its present form, it has existed from 1920, 104 years. Even if we exclude the MAO portion. And then if we include that, it's 150 years. Plus, AMU is one of the main factors, if not the main factor, for creation of an educated Muslim middle class in India. It is responsible for it and it continues to nurture it. If your lordships were to come to a conclusion that it's not a minority institution, my respectful submission would be that would gravely damage that role which AMU has played. Because with that background, my two submissions I'll just flag and then I'll go into them. Because the first submission is that the distinction between establishing an education institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha.
Distinction between
Establishing an educational institution and the device to bring it into legal existence is well recognized in our law, which has been completely ignored by Basha. Well, that's my first submission, which I'll seek to develop. And that's the meaning of established for the purpose of Article 30 of the Constitution. Because my respectful submission is, it conflates, obviously, establishment and incorporation. That it definitely conflates. But what it also conflates is established by and established through. It is established by a minority through the legal device of a statute. And this distinction is actually the fulcrum on which all private universities exist in our present day legal regime. I'll show that. Your lordships will just have volume 3I. I just want to show the distinction between established by and established through. Volume 3I, my lords, will have.
volume 3I.
Distinction between established by and established through. Volume 3I, my lords, will have.
Volume 3I.
I for India, my lords. Page 3 of that. Because this is a UGC regulation. It's called UGC Establishment of and Maintenance of Standards in Private Universities Regulation 2003. It begins at page 2, my lords, of volume 3I. I am referring to, my lords, the definition of a private university at page 3, 2.1. University means university duly established through a state/central act by a sponsoring body with a society registered under the Societies Registration Act 1860. The law, the statute is the device. The establishing authority is the registered society, in this case a sponsoring body. Well, that's the fundamental distinction in my respectful submission which Basha misses. A statute can be the legal device, known as the highest form of legal device, undoubtedly. There can be lower forms of legal devices. A registration certificate under a Societies Registration Act. That is also issued by a governmental authority. By the logic of Basha, that is also established by the government. Now, my lords will have just volume 3H. Just the private university regime is based on a sponsoring body Normally, my lord, it's a business house or it could be a charitable organization which establishes a registered society. They prepare a plan, they put it to the government of the day. The government either enacts an act bringing that university into existence, separate act, or there are states which have a regular one act and you add it as a schedule. So as you come along, you add one university after another as a schedule. Now in that respect, my lords will have volume 3H.
What about 3.1?
Emphasize the larger principle that the legal instrument is only a device. Because obviously, if Basha is right, let's test the proposition. Under Article 30, we are interpreting the word established. Every establishment will be by some legal action. Minorities can never establish anything, forget a university. Because it will be even if a college is there, it will be a registered society. The registration will be issued by a authority, established by that central government authority, registrar of societies. Instead of parliament, central, this is imperial, the finding is, it's the imperial legislature, instead of that will be established by registrar of societies.
But don't you think that...
That's exactly, I'm so grateful to my lords. I'm just coming to that. Because in fact, the private university regime also has minority institutions within it. And because 5 of those institutions are relied on by learned solicitors in his written submission. I'll refer to them. And all of them in fact support our point. So my lords, with that just come for a moment the UP Act. And that is in volume 3H. Kindly have volume 3H. Page 231 is where it begins. Kindly have page 234. 3H.